Okay, as usual, I'll read the question. I hope I am loud and clear because now I'm using my desktop. Am I loud and clear to all of you?
Yes, sir.
Okay, good. Okay. So you have one client coming to see you, Mr. Amin. Okay, Mr. Amin is here troubled with something. Okay. So Mr. Amin approached you and said that I'm the manager of XY Bank Berhad, a licensed institution under Financial Services Act 2013. Okay, for your information, we have two Financial Services Act. Now, whatever the institution that dealing with money, insurance, everything is part under Financial Services Act 2013 and also Islamic Financial Services Act 2013. So any institution that wanted to borrow money should have registered. Last time it's called BAFIA, but now it's all been consolidated, okay, under FSA 2013. And Mr. Amin said that I have been instructed by the head office of the bank to seek your advice and pursue a claim against our panel valuer and also panel solicitor. Okay, so you are clear from this paragraph alone, you have already make out who is the plaintiff and who are the defendants. Okay, very important. Now, the next paragraph, we are going to explore the relationship of the parties. Because bear in mind, in this tortious claim, the usual typical question is negligence. So the relationship, the nexus of the defendants and the plaintiff will usually come into the play in second paragraph. Okay. So the story goes like this. J.R. Sendirian Berhad is our panel valuer as well as a chartered surveyor and a registered valuer. Okay, and its director. Be clear with this word. So now we are looking at what? The first defendant, that is our panel valuer, is a Sendirian Berhad. Okay, now you are looking at two names, of the panel valuer. Whether it is J.R. Sendirian Berhad will be the suitable party to sue or RJ as the director of this company. Okay, so both of them seems to involve in this case closely, in which RJ, being the director of this company, was actually appointed by XY Bank Berhad to prepare the valuations report for the bank with regard to two banking facilities to AB Sendirian Berhad. Okay, now you have the third name coming out, AB Sendirian Berhad, but this one is not very important because the subsequent fact will reveal to us they are not the party to be sued. Comprising of an overdraft of 4.8 million ringgit for the purchase of two units of factories in Taman Waris, Muar, and term loan of 12 million ringgit for the purchase of 4 units of industrial buildings at SS2 Muar. Okay, and now we have the following name. Okay, CD and Partners is our panel solicitor who was instructed to prepare the loan documentation. Okay, now you roughly make up already. The potential defendant will be J.R. Sendirian Berhad, RJ, plus CD panels. But don't be happy at this level because subsequent fact will tell us CD partners is probably a sole proprietorship, Okay, later I explain why. We suspect that all three parties so they try to induce you already. Three parties will be named as defendants, but you have to be critical in this question. Okay, so three parties were in cahoots with our branch manager. So what they did, Mr. Manager and Loan Officer they did what? They inflate the value of valuation report. And then this is not something uncommon actually. In order to get bank loan, usually you have to put collateral, like something backing your loan. Okay. Take for example, this the AB Sendirian Berhad here is the borrower, isn't it? So they have to back with land, and then the bank would not know the value of the land without the valuer report. So this is how. And usually the valuation of the land will normally higher or compatible with the loan dispersed. This is how the industrial practice should go, because the bank also must think of their risk, isn't it? Let's say, for example, this land only worth 500,000 ringgit. It is not possible for the bank to release bigger amount of money, because eventually, if let's say the company defaulted, then they are looking at hutang lapor, the bad debts. Okay. So what they did is that they inflate the value. Okay, this one you have to remember by your heart and jot down the notes, because it is there for a reason. We have obtained an opinion from a valuer from V. Sendirian Berhad, who is willing to testify the market values of each the factories is 1 million ringgit, while that of industrial building was actually 1.5 million ringgit only. So with this expert opinion, so-called expert opinion from V, so the bank realized they got cheated, some sort of like they got misrepresented or being cheated, to be very simple. So when they prepare their loan documentation, they make full reliance over the valuation report tendered by J.R. Sendirian Berhad. So this is how, okay. And they are at the opinion now, both parties from the valuer side, you must remember, there is one J.R. Sendirian Berhad plus one RJ. And the sentence is quite sweet and clear. They grossly, deliberately, and unreasonably inflated the valuation, and there is no reasonable basis for their valuation. So, on top of that, they breached and did not comply with the Malaysian valuation standards. Okay, as they did not rely on similar comparable properties in terms of same locality and proximity to the land in question, and did not consider the transaction over 2 years prior to J.R. Sendirian Berhad. Okay, at the end of this class, I will show you what is a valuation report looks like, so you have a better understanding, extra knowledge. Okay. So instead of relying on the properties in Muar, RJ went and relied on the valuation of properties in Batu Pahat. The distance between Muar and Batu Pahat is quite far, and it is separate district in Johor. Because true enough, I am from Muar and I have a office in Batu Pahat. All right. So it take about 1 hour. Traffic quite smooth one, to transit from Muar to Batu Pahat. Okay, so two totally different locality, I would say. So eventually the bank also feels their panel solicitor. Now you have a tricky part. CD and partners had wrongly advised the bank to release the banking facilities to the borrower, AB Sendirian Berhad, and failed to ensure that the documents comply with the bank's requirement. Okay, as well as fail to examine the documents carefully before advising the release of banking facilities. Okay, here is the catch. CD Partners itself is a law firm. Take for example, I'm Dr. Shi, isn't it? I can set up a law firm only with myself inside this law firm. It's a sole proprietor, but I can call my law firm Chi and Partners. But it doesn't necessarily mean that I do have partners exist. It's just a nomenclature. Nomenclature. It's like a name for that firm. Okay. And To be quite sure here, Mr. EE is the sole proprietor who was tasked with the loan documentation. So you can see this CD and partners is actually a firm name, but EE is the right entity to be sued. All right, so this is the cash. So what is the liability, or what is the mistake committed by Mr. EE here? So Mr. EE informed the bank that he had prepared two sets of identical SPA and also MOT. So this one is actually not an acceptable one. One set was based on JR's valuation report, and another set was actually for 1 million for each of the factories and 1.5 million for each of the industrial buildings. And being a bank panel solicitor, you see, Mr. EE even depart from its ordinary course of business here. Instead to listen to the instruction from the bank, he followed the instructions given by the borrower. And you may know it by now. A lawyer should only represent one party. We are like a agency law, we cannot represent both parties in a cell. If you want to represent both parties in a SPA, you can represent vendor or the purchaser, but one of the party must sign a consent or declaration to say that they know and they don't object this transaction is done by you. Okay? And what happened here is that Mr. Manager and Miss Loan Officer had also conspired with them, I would say, and they have no objections that the second set being used for stamping purpose to save the stamp duty. So probably this Mr. Manager and Miss Loan Officer, some did really happen to tell you the truth, is that they have double version of agreement so that they caught their customers, and to achieve their so-called key performance index. Every bank in each location, if you are close to the branch manager, then you'll know they have a certain KPI, how much loan to release per month. Otherwise, they will be asked by the HQ to attend meeting, etc. Okay. Now, what happened was that the borrower, AB Sendirian Berhad, had been wound up, so gone already, this company. Okay, the guarantors also declare bankrupt and securities sold. Nothing left, Okay, and the two Taman Waris factories sold for 800,000 ringgit each, while four industrial buildings sold for 1 million at each at an auction. So at the end of the day, probably some disciplinary action or also probably some criminal breach of trust case will have been lodged by the bank, and the bank did not wish to pursue the liability of Mr. Manager and Miss Loan Officer. Okay, and now you have to advise Mr. Amin here. So what is your advice? Number one, your question must cover what are the possible causes of action that arise, and your advice should also indicate any defense as to liability available to any person or persons identified as prospective defendants or defendants. Okay, so we go comprehensively step by step. Okay, identify who is the party. Plaintiff here, quite clear. XY Bank Berhad, and you do have a few sets of defendants, I would say. You have JR Sendirian Berhad, which is a Sendirian Berhad, a company that has valuer and also chartered surveyor. And then you have one individual called RJ. So RJ is the director of the company only. And EE, okay, I will not put CD partners as one of the defendant. It's because sole proprietor, you have to sue by um the name lah, easier. You sue by the name. So how you quote is that EE trading in the name and style of CD and partners. Okay. And we have to leave Mr. Manager and Miss Loan out of this picture because the question clearly indicated the intention of our client is to not to sue. And then AB Sendirian Bahad also is not in the picture because would not. As the MBHD would not, and also guarantor bankrupt. Okay. No point to sue. And the potential cause of actions here are what? Okay, you have to list down first. These are the potential cause of action. As per Tort itself, this is definitely a professional negligence because you have one lawyer in the picture already, and you have one atypical species of negligence. We call negligent misstatement. Okay, you will also possibly make out of thought of deceit because a lot of suspicious circumstances surrounding with the transaction here. Okay, and apart from that, you have to look at the question. Even though this is a tortious question, you may also want to challenge that there are some contractual cause of action. For example, fraud, misrepresentation, or even breach of the implied term of the contract. And since there is a solicitor and also client relationship is quite established in Malaysia that there is a fiduciary relationship. That means to say fiduciary is something that is more holy moly. That means you have to be faithful, loyal to your client. So this relationship has been breached by Mr. EE. And looking at this one very particular point that you should not miss out and miss out in your entire career is that if you are looking at negligence per se, pure economic loss by right, pure economic loss, I repeat, you should go for contract because contractual relationship or commercial relationship cause economic loss, to be strict lah. But whereas if you are talking about common law traditional principle of damage, we are looking at personal damage. For example, you lost your eye, you lost your hand in one accident, or property damage. Like you langgar with your motor, the motor all write off by the insurance, total loss. So these are the property damage. You lost your wallet in this particular accident. Okay, it's different. The harm is different. The damage itself is different. So pure economic loss is not typically recoverable in normal negligence suit. Be reminded with that. Pure economic loss is not typically recoverable in negligence suit. So you have to really lay this out in this exam for you to pass. Okay. Now we are looking at professional negligence or negligent misstatement as our first potential and most arguable cause of action. Because this one, no doubt I said if I'm the lawyer in charge, I will probably not file a tortious claim. Rather, I will file a contract claim. Easier. You do not have any problems, okay? Remember, this legal field is very, very smart one. You are being caught with one loophole, your entire case will doom, All right. So, first thing first, you have to identify when an act really occurred. Is it something positive act or it is a negative act or we call an omission or it is just some statement made by the parties. Like here, the valuer, in fact, they did not do anything much. They just give you a report. Whether refer or not is actually coming from the bank. Correct? My duty here as a valuer is just to write a valuation report. Then I submit. My duty actually complete, By complete, you engage me to give valuer's report. Okay, I based on my knowledge, I write you a report. You read it, you want to rely it, is your problem, not mine. Right? So this is how, okay. As I've told you, this is not typical personal injury case, okay, because it doesn't involve any property damage or personal injury harm, okay, and it is against these two set of valuers lah, okay. You may want to frame it like a professional negligence, but the duty of care is different level, is different threshold as compared to typical negligence case. In the very first paragraph, if I'm to argue the duty of care, I will never, bear in mind, I will never put the duty of care based on neighborhood principle. Donahue and Stevenson has no room to apply to be applied in our current case. Okay, very important. Let's see the second duty of care. That is the Caparo and versus this Dickman threefold test will be applicable or not. If you have an opportunity to read this case, then you should know, okay, there are uh, three principles. The first thing is whether the damage was reasonably foreseeable by the parties in order to establish the duty among themselves. Foreseeability is one. Second, proximity, whether parties are really close enough in their relationship, Okay. And the third one, whether it is a public policy. I will put it as very simple term, fair, just, reasonable. Some people tend to call it a public policy to impose duty of care. All right, threefold tests are very important. But TMB and Batu Kemas case clearly distinguish two species of damages. Okay, which are the first one is the one that we are going to discuss tonight, pure economic loss. Can you all follow? Can you all follow so far? Before I go on, a bit difficult, this question. Okay, so pure economic loss or consequential economic loss. Okay, pure economic loss, take for example, here the bank lend AB Sendirian Berhad 12 million plus tadi berapa? 4.8 million ringgit. So other than that, the bank does not lose any money, isn't it? So this is pure economic loss, you see? It's like the bank get interest, isn't it? It's like one part of investment, You put it there willingly, voluntarily, but how can you claim by negligence? It is not allowed under TMB against Batu Kemas by right. Okay, it is not allowed pure economic loss. See this thing. But there are second species, Second species is consequential economic loss. Consequential economic loss, I give you a typical example. Okay, if if I buy, okay, if I buy um buy a car lah, take for example, and that car is actually not governed by Consumer Protection Act one. Don't get me wrong. There are a lot of tricky areas of law. So that car suddenly lost control, and then I lost that car in totality. At the same time, I got some personal injury out of the accident. So consequential economic loss typically refer when I got injured, my bill of hospitalization, my loss of health, like for example, I need to follow up, loss of earning, all that is consequential economic loss because of the damage to my physical self or property. So this is recoverable. Okay, be clear, two different species. Okay. And since we are talking about the damage is pure economic loss in this typical question, the authority found in the syllabus that you are having is Cooperative Central Bank against KGV and Associate Sdn Bhd. And this case concern about negligent valuation, and also the bank suffered from loss due to its reliances on valuation report. Okay, so this is how you made out the case, and this case is very important. I'm not sure how many of you are still remembering your UK law, Hadley Burn against Heller and Partners. So this is a typical um, case that you have to do and you have to apply when you talk about negligent misstatement. Okay, and in order for you to establish the duty of care, duty of care means scope, what is the scope of responsibility? Okay, he must have this word, assume responsibility. And that assume responsibility is coming from the defendant. Okay, in which to say the valuers should have or ought reasonably know the recipient will rely on the expertise, on the specialized knowledge they have. Okay, quite difficult. Okay, so applying these principles, you have to go back to the facts of this case. Don't just reject the law, no use. You have to say a few things. I make it simple for you. Actually, I put in a diagram here. Okay, so what is the fault by the JR? Okay, so their duty here is that the panel valuer and they have been entrusted to prepare the valuation report. And knowingly, the bank will rely on them because they are not third party, they are the panel valuers supposed to protect the interest of the bank. But instead of protecting the bank, they went haywire. Okay, they went rotted lah. Okay. So you have to say the facts here, and then you have to talk about the issues in contention. And the second defendant is RJ. A bit of room to argue is that RJ, we have the fact is silent whether he's a professional valuer. If he's a professional valuer, the liability is on the professional relationship. But whereas if he is just a mere director, he will be shielded by Companies Act 2016. Because Sdn Bhd is formed because of laissez-faire economy. We need to encourage people to join this business, to set up their business without personal liability. Let's say, for example, if I'm a director of a company, any financial loss relating to this company, I don't have to sell my personal car. I don't have to sell my personal asset. We can hide behind the vehicle of Sendirian Berhad. So therefore, it will be wise for you to discuss the corporate view doctrine. Anyone know about doctrine of corporate view or not? Press against prestodial resources. Corporate view. Okay, very important. You can't sue RJ as of right, to be very simple here. Okay, you need to, if he's just a director, as the question might suggest, you need to leave the corporate will in order to sue him. That means will means what? Something like sari, you can't see. I'm wearing a will. Okay, you can't see my face. But when I leave my will, it's like last time people get married, my time lah, they wear a will. Then for you to declare man and woman in life, the husband need to lift up the will. Oh, I'm sure I'm too old for you lah. Okay, but that is the issues here. Lift the corporate view, then you can sue the director. This is not automatic right, but against lawyer it will be easier because professional a bit susah lah. Personal liability lah. If you are negligent, unless you are the one that fall into limited liability partnership LLP. If you are being a partner of the firm or the sole proprietor of the firm, you are negligent in handling the case and cause losses to the client. You are personally liable. That means to say people can sue you and for your own house and also your own car and your saving in the bank. Okay? So this is the duty. And you have to argue based on the facts itself. Okay? How you want to write is that you write something like this. Okay. Okay. So because they are needed to do valuation report, and then that report, they know the JR Sendirian Berhad know will be relied by the bank. Okay. And therefore, these three element presence, okay, possibility, reliance, and most importantly, I think is this one, two things. Reliance and also assumption of responsibility are present. Therefore, the duty of care established. Not easy, not neighborhood so easy. Okay, you have to argue a bit more. So RJ being an individual, he's not automatically contractual liable or tortiously liable. Okay, he will be shielded under corporate view. Okay, just have a bit of reading lah, so that next time you know lah, you can't just sue a director directly. Okay, and it is only in evasion and concealment case. Take for example, there is a fraud. You want to break the law and you want to use this company as a shield so that you can scam people money. A lot of people do that. Okay, these are the exceptional case whereby the corporate shield will be lifted. Okay. But if take for example, he's a professional valuer, that will be a different story because professional liability, you have to take the responsibility because if you are a valuer, then you are registered valuer with the board of valuer in Malaysia. It's different. Okay, like for example, a lawyer is registered with the bar council, Malaysian bar, isn't it? So we are registered with a body, like accountant, they are registered with this lembaga accountant. Okay, so these are the typical board that will put on personal liability on you. Okay, so like this. And third defendant is slightly easier because You know that he's a lawyer, and therefore he has a contractual duty, fiduciary relationship, and also he is capable to be professionally negligent for the whatever mistake that he had done. Okay? So we are clear about the duty of care. Huh? Are we clear? Are we clear with that? Okay, But this question a bit difficult, I would seriously say a bit difficult. But okay, after you have discussed the breach of duty, then you have to compare the standard. So what made you to say so? You established the relationship already, but you want to say this person is a bad boyfriend or a bad girlfriend. You must have a certain benchmark to compare, isn't it? So this is how. So JR and RJ standard has been told in the facts itself. Take for example, they choose Batu Pahat over Muar to compare. This is wrong. They choose the database that is happening like not within 2 years. And the market value of the land typically change over the years. If it's not increased but will drop lah. These are the two trends. Okay. Instead of doing so, they choose a very backdated punya years. And the valuation is totally wrong and not according to Malaysian valuation standard. And more importantly, to establish a professional negligence, typically you may need an external or independent expert in the trial process to prove to the court, look, this is a professional person. I'm also a professional person. But what he did is substandard. Okay, so this is going to section 45 of Evidence Act, expert opinion, and you have to file affidavit baka. Okay, and lawyer also same. Lawyer will also compare with the standard of an ordinary and also prudent lawyer in practice. A typical SPA lawyer will do the same mistake or not. Okay, but clearly on the facts, this lawyer and also valuers would be quite likely to be found liable. Okay, because they truly have fell below the standard of care required. So this is how you develop your question. And third element is that you have to show causation. Okay, to be very honest, and in practice, to establish duty of care, to even show the breach of duty of care is not so hard. Causation is typically difficult, especially you have a lot of parties involved. Take for example, you see, now you have AB, what we call Sendirian Berhad as the borrower. At the same time, you are engaging the intermediaries, the Miss Loan and also the loan Mr. Manager here as intermediaries to wash your file. At the same time, not only that, you are involving the valuer plus lawyer. So actually, the damage is caused by who and caused by what? What went wrong? Very hard to tell. You get me? Or I give you one example that I typically deal with. In medical legal cases, we have substantial difficulty to prove causation. It's because sometimes not only one doctor treating the case. Like one doctor treat an elderly, okay, with fracture of neck or femur that one is quite typical elderly woman osteoporosis, they will come with neck of femur fracture if they fell down. Okay, so one doctor will be taking care of the bone. At the same time, there will be a geriatric medicine, typically from those internal medicine field to look after underlying diabetes, underlying heart disease of that individual. Let's say, for example, this individual was illy treated or the standard of care had been fallen. At the end, the patient died of stroke, something not related. So, where to establish causation as to the damage itself, very, very hard. So does with this case. Sometimes, but for is very difficult. You may need to resort to material contribution tests. Have you heard of this before? The test for causation. It's not just the damage will occur, but for the action or the non-action of the defendant. It's not like that only, Sometimes the fact is not very clear. You may need to resort to material contribution. It's like because of this defendant's action, it has material contribute to the damage. I'm not saying that you have to take 100% fault, but you have contribute a lot here. You get me, huh? Okay. But somehow rather, on the fact, I think but for test is suitable. Okay. And legal causation is also legal causation is actually easier. Factual causation is difficult. Legal causation is reasonable, foreseeable. Okay. That means to say within the contemplation of the parties, not something that happens out of the blue, something that is so surprised to know. I never know you will suffer loss if I put a valuation report like that. I never know that you won't suffer loss if I did a crappy job in documentation, your bank loan, bro. Most likely lah, to fit in the position of Mr. EE here. Okay. And fourth element that you have to put in this tortious claim is that the damage. Okay, damage here is a pure economic loss. Okay, normally you don't have to argue damage more because this will be answer for question 1B. Sorry, 2B. Okay, question 2B. But you have to say the plaintiff suffer from some form of damage. Okay? Apa kerugian yang dialami oleh plaintiff? Mesti ada. Kalau tak ada, tak ada kecuaian. I give you one example that I always have. One patient will say, "Oh, that clinic gave me the wrong medicine, and I have eaten it for 1 week. But at the end, I will ask, what damage you suffered? Are you getting hospitalization? Are you unable to work?" You said, "No, tak ada cuma salah ubat je." Can you sue for negligence? Cannot. You cannot take opportunity of some other's mistake. You must suffer real harm, real loss. Okay? You don't go to court for some speculative thing. Okay, real harm, real loss must be suffered. If you do not understand, I have used ChatGPT to summarize the whole argument here to make your life easier. Understand what is it about, then you fill up the blank with your case law. Okay, that is more important. So element, I've talked to you, the same thing only, but in a summary form. Okay, remoteness. Okay, the second cause of action that you can make out is what? Tort of deceit. Tort of deceit, just like tortious claim, it must comprise of elements. The first element, false representation, and second element is that it is false. The knowledge itself is false, okay, and a bit overlapping. It is quite common. Even private nuisance occupiers liability, you can see there are some elements overlapping with negligence. Tort, the big brother for tort is actually all coming. The root for tort, I would say, is from negligence. And other fancy name, Ryland Fletcher, all that are built on top one, if you know a bit of origin of the law here. Okay, so there are some overlapping here and there. And you can also see in order for you to establish the tort of disease, there are reliance, okay, and loss caused by that reliance. That is the damage in negligence case, isn't it? So on the fact, what happened? The valuation report was deceitfully prepared by the parties and also suspicious circumstances. Like why you prepare the lawyer typically, why you prepare two sets of loan document, the SPA and also the transfer document. Okay, so you have to know, you have to argue. And the third one, you do not need to argue too much, but you have to show to the examiner that you realize there could be some contractual element filed over the parties, because having said to be your panel valuer, to be your panel solicitor, you are contractually bound with the bank. So contractual will be one of the cause of action. Okay, but again, if you are to make this claim against RJ, you may have problem, because RJ will say during the trial, there is no contract, because RJ Sendirian Berhad is getting the consideration, is getting the payment from the bank. RJ personally, maybe as a director, he will get his director remuneration, director salary. But he's getting money from RJ Sendirian Berhad, not directly from the bank. So probably contractual claim against RJ is weak, is weak. And fourth cause of action is the breach of fiduciary duty. That one you can establish against EE as the lawyer here. Okay, so the duty of the fiduciary duties here refer to good faith, loyalty, no secret profit, and you have to make a full frank disclosure. Just like, for example, being a director of a company, I give you a scenario. I cannot make secret profit. Let's say I have a recycling business. I set up Sendirian Berhad A, and then of course I caught you guys lah. You have 24 people here. I caught you guys as a shareholder. So being a director, I owe a fiduciary duty to the company. I must act in good faith, and I must be loyal to this recycling company. I cannot behind you and set up another company to do the similar industry, or I cannot solicit the existing client of this company just for my own profit. It will amount to breach of fiduciary duty. Similar thing, being the lawyer of the bank, you have to protect the interests of the bank. Okay, not the borrowers. Clearly, here, this firm and this lawyer had made a very dishonest departure from the his normal route. Okay, and the available defenses also you have to argue. Okay, first thing first, you have to say that since this is a pure economic loss claim, probably you are stretching the duty of care too much here. Okay, believe it or not, they will argue. In reality and in practical, they will argue there is no duty of care owed by JR and RJ to XY bank. Like I have told you, my duty is to prepare the valuation report. I did not ask you to refer. It's different thing, altogether. You may find it a bit of tongue twisting to digest it, but this is the reality. Okay? And the scope of retainer. Okay, you are just engaging me to prepare a valuation report, but you did not retain me to make sure the valuers report is really up to the par. That will be one argument. You are just merely engaging EE so that the transaction will go through. This is a form of formality. You did not engage me to oversee how much the loan should be released. What? It's your duty. It's the bank duty to release how much. I'm just like a boat, to travel to the destination that you ask me to go. You give me the instruction, I prepare, and in fact, SPA prepare everything. What? It's done. What? Correct or not? So why should I extend this scope of duty to I have to take care when the loan default, when the valuer's report is not, is it? Not like that. So there will be the arguments of the parties. And third, remember, contributory negligence. Even though bank had dropped the civil suit against the Miss Loan and also the Mr. Manager. Let's not forget, they are also the employees of the bank. They will have facilitated the loan process. And because of their mistake, and also they did not exercise adequate due diligence on the part when performing their duty, there is a partial defense open to the defendants to lower the claim of the bank also. So you have to refer to Section 12 of Civil Law Act. Okay, very important. And you have to highlight to the examiner that this is a partial defense. This is not absolute defense. Absolute defense means the court will make out a judgment saying that, okay, even though all the elements of the negligence has been established, but the defense is complete. That means still, the defendant is not liable to the loss of the plaintiff. Okay, so contributory negligence is a partial defense which will result in difference in apportionment of liability. Okay, and this sort of attribution is obviously fact sensitive. Depends how much contribution that ought to be responsible by the bank. And fourth element, not a good argument, as a matter of fact, is that they will argue illegality issue because the bank also actually to come to court you better, I mean the word is often really used, is that you better come with clean hand. If your own agreement or that is tainted with illegality issue or something that is not within the boundary of law in Malaysia, the parties, the defendant will typically bring the illegality issue to bring it down, as in the court has no jurisdiction to enforce an illegal documents. So the subject matter of dispute is largely concerned about the SPA and also the MOT. The MOT is Borang 14A, with the land office you sign and then transfer name one. Okay. Since there are some elements of illegality, particularly with the stamp duty issues, it will be tainted. If it is tainted, probably the whole course of action. But of course, this is a very weak point, I mean, in these particular facts here. But in reality, it will be a cost for the opponent to turn the whole claim of the plaintiff down. It could also be one of the typical issue for appellate court to intervene. You don't want that to happen. So usually we will ask the client, do you have clean hand? Do you have anything that I should know? Because business, how do I put it? Sometimes you have to resort to gray area. Gray area means you are not so white, at the same time, you are not entirely black, but somehow you're gray. Okay? And causation. Causation is the one that I've talked to you. What is the loss happening here? If let's say I give you a hypothetical scenario, if Abby Sendirian Berhad follow the agreement, the guarantor also follow the agreement. He step in when Abby declare winding up. The loan will be fulfilled. The bank will not suffer from loss, isn't it? So is the loss caused by the lawyers or the valuers or the breaching party? You have to think. And the defendant will argue it during the trial because there is a true element that they love to use. There's a break of chain of causation. Think carefully. Think, and be smart. Be smart. Okay. All right. You understand at this moment, because to be sure, AB Sendirian Berhad is the one that default the loan. I didn't get money. As the lawyer, I don't get 12 million from you. As the valuer, I didn't get 12 million at my end also. I just got a bit of legal fee. All right. So why should I be paying you 12 million? This is something for you to ponder. Okay. Is the real damage caused by the defendants you name or not? All right. Can we proceed at this moment? Can we proceed? Is it clear enough for you? I hope it's clear, by the way. Okay, when we talk about damage, how you want to do your question is that you have to follow the style you pray in your relief, the last paragraph of your statement of claim. Usually you will state your head of damage. So you follow that style, easier for you. No need to argue here and there, haywire. Okay. So the principle governing any tortious claim will be restitution. Restitution means to put in original position of the parties had the tortious act itself not occur yet. Okay, like for example, if the accident did not occur, what will be the typical legal position of the party? If the so-called negligent misstatement occur, what will be the position of the party? Like for bank, it's quite easy. The bank will say, I will not have loaned the 12 plus 4.8 million out, 16 million altogether lost. I would have lent it for other people and collect more interest. So this is the position of the party. Okay. And one more thing that you may also be interested to know, since this is a negligence misstatement, there is something called Samko principle. Samko principle had been upheld in RHB Bank against Azmi and Co here. Okay, you can see how they calculate. Now you are looking at the loan dispersed. Okay, this is the case from RHB Bank. Okay, RHB gave out loan 1.87 million. At the end, how they calculate the damage. Okay, the actual loss here is the loan itself, 1.8. But the court adopts Samko principle to say that the exact loss is the differences between negligent valuation, deduct true market value. So you can make out the damages awarded here is 1.3 million. Okay. Anyhow, if let's say, for example, true market value with as compared to the loan dispersed, if you minus, is by right, it's around 987,000 ringgit. But as a result of Samco principle, they are giving more to the bank. You can understand. So they calculate like this, negligent valuation minus true market value. They derive the damage from that. So on the fact, you have 12 million term loan plus 4.8 million. So this amount to total value 16.8 million ringgit. So if we base on the negligent valuation, okay, if you refer to the valuation given in the facts, the negligent value is actually 22 million, You have to do a bit of calculation. I think it's there for a reason. And the true market value, how you made out, is by B. Sendirian Berhad report. 8 million. Okay, 8 million, see, but at the same times, you sell the what we call the building during the auction, isn't it? So the bank will have recovered some loss on their end. So 16 million will have to minus the auction sale receipt, I mean receivables from the auction itself. So these are the exact loss. But instead, the probable recoverable damage based on Samco principle will be 22 million minus 8 million true value. So you'll get more based on it. Okay? You'll get more. Can understand? Valuation for damages can be written like 5 million. Can. But you cannot write in statement of claim like that. Statement of claim, you better write everything numerical. You have to put 60 behind the fine. Okay? You cannot write 5 million like that. That is the law. Okay. And then you have to argue the special damages. The special damages is the shortfall. I'll refer to the shortfall. Exact loan plus minus the auction value is about 11.2 million. So this is one of the special damage. Together, auction fee, valuation fee. In the case there are any other out-of-pocket expenses, this will be deemed as the special damages. Okay, remember, special damages. Okay, damages, different, damages. If there is a word S there, means money. This is how I remember. If there is just a damage, means loss, ataupun dalam bahasa Melayu kerugian ataupun kerosakan. Okay, different wording, different meaning. General damages, okay, pleaded for the figure that is not typically quantifiable. It should be up to the court to assess. These are general damages. But at the same time, you must see the court is not a place where you are entitled to get more or get something extra as a bonus. It's not like a casino. Not like that. Sometimes you win 10 times more than the exact value. Cannot. So if the damages itself are overlapping in nature, the court will reduce it. All right. If the court not reducing it, it will be one subject matter for appellate court. It will be go up to appeal. Susah lah. Okay. Exemplary damages. Exemplary damages in the event of tortious behavior that is not acceptable, like the court wanted to give punishment and to give some lesson to the society, it can award. This is something like punitive damages. Because for you to cautious itself come from the word wrong, wrong, civil wrongdoing. It's still a wrong, even though it is not up to the beyond reasonable doubt criminal standard, but it is still a wrong. And the court, by right, as a corrective body, I always use this word, corrective body in the society, it balances the interests and also the rules of law, So sometimes it can adopt an extreme approach, a drastic, draconian move to punish the defendant so that there will not be similar incident to have occur in the future again. So this is exemplary damages and aggravated damages also. Okay, aggravated damages and exemplary damages it is quite trendy to put in any civil wrongdoing now. For example, trespass case, some intentional tort case, assault, battery, or forced imprisonment. We got all these cases, So if let's say the defendant are those nasty, not cooperative, and you know that their conduct in handling this suit, they'll file a lot of discovery lah, they'll file striking out, all that it will give you aggravated damages, Sometimes you'll be surprised, aggravated damages more than the special damages that you claim, So this is the species. And aggravated damages are those that the court feel like you have suppressed the claimant's feeling and also dignity. And the typical general damages and also special damages here will not be sufficient to cover the loss of the claimant. They will typically award aggravated damages. So nowadays, medical legal damages are aggravated damages coming from the maximum the court can give 1.5 million. Okay, just for aggravated damages, not for hospitalization, loss of income, not yet calculate, For these aggravated damages, medical legal per se, the court can award up to 1.5 million. Okay. Interest and cost, that one is quite common. And mitigation, the bank is duty bound to mitigate the loss. For example, it sells the what we call the property to the auction is one good mitigating factor, I would say. All right. Now we come to the final part. Okay, I would say this statement of claim will not be too easy because why is it not easy? In my personal opinion, because you have different parties, with different nature of business. So whenever you want to make a statement of claim, just for your knowledge, first step is to get the entitlement correct. And this claim is well lies in the High Court of Moa. Why is that so? Because the cause of action have told you is in Moa. So Johor only got two High Court, Johor Bahru and also Moa. Okay, so this jurisdiction, territory jurisdiction, I will prefer to put in Moa because we do know where is the address of the defendant, So we use the cause of action have arisen and also the land, which is the subject matter of this dispute, is from Moa. Okay, and in the state of Johor, okay, sorry for that, Johor, Darul Takzim. Azim, you have to put like that. Malaysia. Okay. Civil suit number All this must follow and in capital font. You cannot write small capital. And between who is the company, the plaintiff, XY Bank Berhad, and the defendants. You have to name it one by one. One, two, three. Otherwise, you will have a bit of difficulty. You have to put dot 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 first defendant, dot 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 second defendant, dot 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 third defendant. I think it's a bit wasting time lah. Okay, so I put JR Sendirian Berhad, RJ, and EE, and be sure that their legal entity is covered inside this statement of claim. Okay, some statement of claim, we have done it also. We didn't put this IC and also company's number. It is acceptable, but for your exam purpose, I think you leave it blank like that is best, because at least you show to the examiner, and this will be your one and only chance to show to the examiner that you know what is the legal entity of the party that you are suing. Okay? And statement of claim here, first you have to introduce the party. Start with the plaintiff. What is it? What legal entity? And where's the place of business or registered address? Similarly, also with defendant is a company. What is it doing? Surveyors, valuers, okay? And what is its address? And what is the relationship between the plaintiff and the defendant? Okay, you have to put it clear from the beginning. Tortious claim, contractual claim is based on the nexus of party, the relationship of parties. If you have no connection with me, or I didn't establish the connection in the statement of claim, I will have deemed to waive this issue. Susah, okay, susah nanti. And the third defendant is the lawyer, advocate, and solicitor of High Court Malaya lah, and also the sole proprietor to have run the business, and also the firm of CD and Partners. And what is the address and what is the relationship? And subsequently, you can state the background of the story. What happened there? Okay, so AB borrow from plaintiff 4.8 overdraft, 12 million term loan. Okay, so just now there's one student asked whether we should put million on that. I would like you to put numerical form. Numerical form. Okay, if you refer to rules of pleading, we have to refer numerical. Numerical. Okay, very important. So where's the location here? What is the subject? Properties in issue. You plead here. And what happened? What happened? This is the challenging part for this statement of claim, because I think the duties are different. And since this is a negligence misstatement, you have to plead this also. Otherwise, duty of care, you may not be able to establish during the trial time, because pleading is everything. You cannot deviate your trial proceeding away from the pleading. So there is a tendency, because the defendant's lawyer is also wanted to win, so they will keep on saying objection, you didn't plead, you didn't plead. So the statement of claim and statement of defense nowadays are increasing voluminous, becoming more voluminous day by day. Last time I remember when I start my practice, my longest statement of claim will be 15 pages. Now we have to go to resort to 30 pages when your statement of claim for medical, legal, and also contractual claim. Ay, so many things to cover inside. Otherwise, objection, preliminary objection. Otherwise, this evidence cannot be tendered. All that become issue. Okay, and you have to plead the valuation report. Okay, valuation report, and also what is the particular of negligence. You cannot simply say Oh, because like that is negligence. You have to particularize, so what is the particulars here? Very important. You copy and cut from the facts. Okay, all these are factually derived. Okay, so you have to put in, if not so much, because this is AI generated statement of claim. So you are allowed to put lesser in exam. Like I have told you from the beginning, you need not to complete a perfect statement of claim, but the structure or the basic skeleton must be there. Particularize what is the facts that is happening. Okay, so because of that particulars, and then the first defendant is liable. The second defendant also liable. Why? Because he prepare and sign, participate, something like that. Assume responsibility. And third defendant issues also different because their work of scope also different. Correct or not? Therefore, you have to spare a bit of time. I think this thought question a bit difficult, a bit difficult. To be very honest, even I feel it. Of course, I'm not hi-fi at this moment, but probably I will be in the future. I think it will take a lot of time for me to prepare this statement of claim also at my end. Even though I have real-time punya practice experience, okay? Because the scope of duty is different, and you have to also particularize what is the negligence element. Most of the students score very little mark for the failures to particularize the event. They just write a template. They copy and cut from the CLP notebook. Oh, because of the negligence of the defendants, therefore the plaintiff suffer loss and damage. Finished. But what is the negligence? What is the issues? What is the facts here? Statement of claim is like a storybook you are about to tell to the judge what is going on here. You get me? If you don't refer to the statement of claim, the judge will have no preliminary idea of what is going on. So you have to be a good draft person to tell the story. Okay? So you have to say what are the negligence. What is the breach here? Okay, failure to examine the relevant document. Failure to advise. Okay, failure to prepare, something like that, or even cost to prepare two sets of sell and purchase agreement (MOT). So these are the one that you can follow from the facts. If you are seriously running out of your time, copy and cut from the facts. Don't left this particular of this negligence empty. You'll lose a lot of mark. Okay, and what is the particulars of loss and damage? Okay, so this is special damage. Damages. Special damages means the one that you can prove with bill, invoices, or receipt. Okay, so these are the things that would have put the plaintiff out of pocket. ABCD. So special damage is in the total amount of X. Put it like that. And last sentence cover most of your answer in 2B. That is special damages, general damages, blah 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 that I have taught. Typical format. Don't write more. Tortious claim hardly will involve specific relief. Okay, you can't be asking tortfeasor to apologize or to revert the accident that happened. Cannot. Usually it comes in monetary damages. Okay, and you have to put a date, your exam date, and sign. Put one line or dot dot dot, solicitors for the plaintiff, and this one start to create your own law firm with address for service. Okay? As simple as that. Anything to ask me, as of now. Is it okay with you guys? Are you still together with me, or I mean, some of you may have fall asleep. Thank God, at least I'm seeing at least one students that I could have enlightened. All right. Okay. Any problems that you feel that you think I am of any of the assistance? This statement look different than all I have seen. Yes, it will be different.